Welcome to Bootstrapped Solo. I am Pratik Shah, your host, and today we're going to be talking about the good, the bad, and the ugly about running your own practice. This podcast is for those that want to know what it's really like to start, run, and grow a practice. Today's guest is Ross Jurewitz of Jurewitz Law Group. He runs a 34-person practice that focuses on personal injury. He's got offices in California and in Florida, and he started his practice back in 2000 and has been growing strong ever since. Ross, welcome to the show.
Hey, Pratik, nice to be on here. It took a while for us to get together on this, but I'm glad I'm here.
I'm glad you're here too, man. You've got some really cool stuff that I want to talk about. I know we did.
Sure.
I had some questions pre-interview, and just for the sake of the audience, we're going to really kind of focus on three things and just kind of tell you what I want to talk about. One, I want to talk about how you started. You started back in 2000. That's obviously 23 years ago. That it makes the math easy when you started in 2000 for me, right? Like 23 years ago. So you've seen the industry change. You've seen business practices change. You've seen all kinds of stuff. You've grown throughout that 23 years. You've scaled to be across, coast to coast. I want to talk about, how you started. I want to talk about how you've grown. And then obviously the big kind of elephant in the room is what happened in Florida recently with HB 837 and tort reform getting passed. And I want to talk about how you as a business owner are going to navigate that and what you think. But let's start all the way at the beginning. I mean, you started back in 2000. What a different time that was.
It was a completely different time. Even pre 9/11, that's how different it was. So I never thought I'd own my own law practice. Never thought I'd start my own law firm. It wasn't until about the third year of law school. I had started at American University in Washington, D.C., met my wife there, who was a year ahead of me. And we're trying to figure out, okay, well, where do we want to go? Do we go back to California, where I'm from? Do we go to Texas, where she's from? We ended up, coming to California. And I did my third year at University of San Diego and was clerking for a solo lawyer downtown. Wasn't doing personal injury. He was actually representing the America's Cup races.
Oh, wow.
That were there. So it's really interesting work. But I got introduced to his associate attorney, who was in the process of going out on his own. He was only about 2 or 3 years out of law school at that point in time. I'm getting ready to go out of law school, and talked to him and was like, okay, yeah, this actually kind of makes some sense. Do I want to work for other people the rest of my life? Do I want to work for myself? And I'd already had some experience all my life doing some entrepreneurial things, always hustling for money. One of the great gifts I always say to my parents is, they always valued education, but it put me in a place where I thought I was poorer growing up than we actually were.
Yeah.
Nothing came easy. They could have given me money for all the things I wanted, but it was like, hey, at the very least, you got to earn half.
Right.
And maybe we'll match it on that kind of thing. So I always was hustling, trying to get money together. I was always doing those things. So that kind of thing appealed to me, to have control, to have control over my life, control over my practice. So I started reading some books from the USD Law Library.
What'd you read?
I read a couple that I don't recall most of them. The one that sticks out is Jay Foonberg's
On Start, Run, Grow Law Practice. Yeah, that's the classic, right?
Yes, exactly. Yeah, I think everybody who's ever done that has, who's ever had a law practice, they've started with that book. What do I do? Like, what's, how does this all go about? And it's a good way to, especially for a law student, for them to jump into solo practice and do things. But that's really basically what I did. Is I graduated, took the bar in California, sat around waiting for endlessly for my results until Thanksgiving, and then got my law license and started shortly thereafter, and didn't have any money. I mean, whatever was in the checking account was what I had. Found a cheapo office that was furnished in the Del Mar area of San Diego. Had a couple of lawyers in there. They were feeding me some cases, they're feeding me some appearances, and really just was practicing door law.
Yeah.
Whatever came in the door, figure out how to do it, and take care of it, and try to see how things would work. Wasn't doing much contingency, but doing some. Mostly it was hourly billing, which is a challenge, and I learned in that year and a half where I was a solo. Initially, I didn't want to do billable hours.
Yeah,
that was not the way. That was not the way to do things. But one of the lawyers that I met in the area as I was, hustling to go try and find some work, and I literally went through and found like a list of 200 lawyers and started sending out, this is how different things work. I started sending out faxes.
Yeah.
So faxes, not emails.
Yeah. Well, let me, that's what I was going to ask you is, in 2000, it's not like, nowadays everybody kind of, obviously you got social media and you've got Google AdWords, and you got a lot of digital marketplaces where you can go and put your name out there and say, hey, look, I got a nice big office. I'm a big lawyer, even if you're not. 2000, you can't really fake the funk. You know what I mean? Like, people knew right away if you were starting out and you were just in the early kind of fetus stages, I guess. And so how did you get business? It sounds like you were just getting into that. You were talking about you would get a list from somewhere. Where did you get the list from?
I think I got a list of lawyers in the area. If I recall correctly, it was either through the County Bar Association or something, and I would basically self-filtered it probably by zip code, like who's like local there in the area, who can I go call on, or you got a fax number, whatever. So I sent out faxes to me. It's like 200 lawyers asking for like referrals, appearance work. Hey, can we meet for a coffee, whatever it is. Was doing that. Was doing
and this is not e-fax. This is real fax.
This is actual fax. This is
like at a fax machine, punching in number by number of 200 lawyers to fax them a letter saying, hey, send me work.
Yes, and I didn't have any money for an assistant, so this is me manually doing this, for 200 times, and then. After I get done with that, didn't get much in the way of responses, but I did get some. Doing, sundowners at, Chamber of Commerce events, doing whatever I can to kind of get my name out, going to county bar events, going to consumer attorneys I joined, back then and was doing meetings, just network, kind of thing. And you had to really own where you were. Look, I'm a baby lawyer. I'm hungry. I can do the work. Give me something to do and I'll do it for you. And, really for the first year, it's starvation, but it's good. It's good building that up, and you learn a lot of things. I went to mediations, depositions for other lawyers doing contract work, did a ton of appearances, and talk about, learning how things go, learning how the actual practice of law works in litigation. Honestly, I recommend for everybody, if you can go in and just do appearances and just learn how to BS with other lawyers and BS with the judge, and kind of know, this is what the judge wants during this hearing. This is what he wants. He doesn't want to hear anything else. Just get to the point, take care of that, and do it.
I did a lot of appearance work when I started, and I agree 100%. And I don't know how much of that, it was a really easy way to make a couple $100, right? If I didn't have anything on calendar that morning, and in the beginning, you just don't have anything on calendar because you don't have any cases. And so somebody wants to pay you $80 or whatever to go cover an appearance for them, you go do it. And like you said, you get to BS with other lawyers, you get to see how the system works, and you get to see it's not that crazy. But also, I think, I wonder today if that's still an opportunity for younger lawyers with everything, a lot of hearings going remote.
Yeah, I'd have to imagine I'd have to imagine it's less of an opportunity because everything is remote, and it is less of a hassle to show for status conference, case management conference, something that quite honestly, if the judiciary was interested in saving some money, they'd even go beyond virtual appearances. They do something that is like a Google form or something like that to just go through it and say, okay, great, we're just getting dates. Like, why are we wasting lawyers' time? Why are we wasting the judge's time on things?
Yeah.
But yeah, I mean, I don't know if that is as much of an opportunity. I mean, I know for myself, even showing up at a Zoom meeting for CMC is not worth my time. I would rather somebody else do it. So there's probably still some opportunities out there.
Exactly. And that's what I was going to say is just because that's not an opportunity doesn't mean there's not other opportunities. And sometimes people that, they look at people like yourself who have been around and have been successful. They go, oh, well, you had that opportunity back then. We don't even have that anymore. It's like, well, you got to go find something else. You can't just throw your hands up and say, oh, well, you had that advantage that I didn't have, so no wonder you were successful. It's like, no. People that have that mentality of I'm going to find a way to make an opportunity, they go and find it no matter what the situation is.
Yeah, and I think that ultimate hustle that you have to have is looking for those opportunities. But on the corollary of that, for those young people just starting out and kind of going, well, hey, I don't have this opportunity, but I can go find something else. Okay, that's one mindset there that is maybe negative. It's not as positive. I can tell you for myself, pricing for 23 years, seeing the landscape change, I actually kind of get a little bit depressed about it and go, hey, that opportunity is now gone. Whereas for a new person coming in, they never knew that opportunity. So the landscape is the landscape. They just go, hey, this is great. We got, I can make money doing other things. And look, there's always good and bad with everything. There's always a yin and yang with the whole thing.
And you just have to you can't just take somebody else's game plan and just execute it for yourself. You have to execute what works for you. Like when you talk about, sending faxes out, right? Like you had to go and find a list from the Chamber of Commerce or the law library or something. This is a manual process. You had to manually type up the letter, print, and fax it 200 times, right? Through the machine, punching in the numbers by hand. And people say, oh, well, we can't do that now. Yeah, but what you can do is you can go on Instagram, you could see 5,000 lawyers and just DM every single lawyer saying, hey, I'm a new lawyer. I'm young. I'm hungry. You got anything that you don't want to work on that I can work on? And I guarantee if somebody does that 1,000 times, they'll get something. I bet if you got a DM, you'd be like, maybe we got a small case we don't want, or somebody called my office on a case we wouldn't take and I can kick it over to this person.
Yeah, it all depends. I mean, I think that the way to do this is say, look, I am going to try something, or I could try something that's going to have a very, very low rate of return. But that low rate of return, because I have nothing at this point, is still something that's positive. And I can build upon that. I mean, for, again, the younger people looking at this, it's always, grass is always greener. You guys, you old guys always had it easier. You guys are a success now. Well, I mean, there's an old saying. I mean, it's 20 plus years to overnight success. I mean, you don't see all the hard work, the grinding, pushing two nickels together to try and figure out how to pay bills. I mean, I can tell you and tell your viewers that my first year in practice, I probably made less than a year than I make in a month now. And trying to figure out how to support myself, support my new wife on that, and still grow practice. So,
and that's something I want to touch on, because one of the questions I asked you pre-show is, what was the budget you started your firm with? And you told me, I think it's the lowest number I've heard. I thought I was a low number. You said it was like $1,000 or something that you had in your checking account.
Yeah, it was whatever I had in my checking account. Honestly, I mean, it could have been a little bit more, but it wasn't much. I mean, I'm just out of law school. I think that clerkship job I was working at was paying $12 an hour. So you can imagine how little I had saved up. And my wife's a young attorney, but she's not really making any money either. So we did have each other to kind of lean on and to starve with. But it was very, very lean. And you get very creative in terms of how you're going to pay bills, how you're going to finance things, and how you're going to get the assets you need to grow your business and get income in.
When you and your wife discussed this idea of, hey, look, you're going to work full-time as an attorney, I imagine she was working full-time at that time?
She was working part-time as a contract lawyer at that point.
Part-time as a contract lawyer. You're working part-time as a contract lawyer. I'm going to go try and start my own firm and see what I can do. And was there a discussion of like, hey, yeah, go for it. And then, but hey, Ross, if it doesn't work out in, 2 years or 3 years, you're going to have to find a job and, start paying bills. I mean, did you guys have that discussion? How did that, or was it just go for it, and as long as it takes, it'll be fine?
Yeah, that was the discussion with us, was that, I mean, it was more not like a ultimatum, or more like, okay, well, this doesn't work out. This doesn't work out. This is what you're going to do. But no, it was basically, look, we're, and Foonberg goes through this in his book, which is the best time to start your law practice is when you have nothing. Because, and I've seen this with other trial lawyers who I knew were going to be successful. They were going to kick ass, and they're going to be one of the top dogs. And there's one in San Diego I know that I talked to for a couple of years, who's now consistently top 1, 2, or 3 plaintiff lawyers there. We all knew he was going to be great, but one of the things that he was worried about was, okay, I've got a family, I got my salary requirements because I'm coming from a job. How do I make this? How do I make this jump? Well, as a young person, you're not burdened by that. You have nothing, so you're going to have nothing still. So you might as well keep keep on growing.
Worst case scenario, you're in the same position.
But one of the lawyers that I did certain appearances for was Jim Hoey, who's no longer with us. But Jim, at that point, was he'd been a plaintiff lawyer in town for a while, and recently had partnered up with John Morgan to try and do a John Morgan's firm out here in San Diego. Was dumping a bunch of money into again, different times, wasn't doing TV, but he would have the back page of every Yellow Page book in San Diego. And
Slightly different time.
Slightly different time, but it was a chunk of change. I mean, it's amazing how expensive those things were. I mean, it's probably about as much as I spent on TV each month is what they were paying for the back of the Yellow Pages back then. And they were getting a ton of cases in. But he had all these appearances. That's, he was sending me on a bunch of stuff to help them out with. And then he offered to bring me on as an associate, again, not for a lot of money, but, baby associate, and worked there for about a year and a half, and then left and went back on my own, and we've been on my own in one way, shape, or form since 2003.
What led to that decision as you were running your own? What led to the decision? Because you said that in the beginning you were doing business stuff, you were doing hourly, you're doing all kinds of stuff. Jim obviously did personal injury. And so at some point there was some exposure to personal injury that made you decide to kind of take that opportunity. So what was that exposure, and why did you decide to, temporarily shut down shop and go work for Jim? Or did you do it concurrently? How did that work?
It is all kind of concurrently. I mean, so I had become introduced to a number of cases, and I had handled some personal injury cases outside of, on my own the first year, and got exposed to that. I like the fact that as much as we hate the insurance companies, as much as they're, really a pain in our neck, the fact that they're a necessary evil that has a pocketbook to pay us and pay our clients when the case is all over, that's a good thing, instead of having to go chase a client later on to go get paid for your services and, getting negotiated down on what they owe you and things like that. So I took the opportunity to, number one, get a steady paycheck and to learn personal injury law. I had maybe a dozen or so cases of my own. Jim let me bring those on and still work through those. And those were PI and still some business litigation stuff. And then, did that for about a year and a half or so. And Jim ended up restructuring his business and going less attorney heavy and more support staff. So I was out of a position, and I took some of the cases along. Jim was very gracious with that. So, hey, look, keep on working on your clients, take care of that, and, kick us back a referral fee, and went back on my own again. But this time was predominantly focused on personal injury. I think I did some business lit and other hourly lit for about the next 4 years, but it's very, very small. And if I got to the point, it was like, this is such a small amount of my practice that it's not worth actually keeping hours on.
Yeah, it's just more hassle than it's worth. Yeah. So you start your practice in 2000. You're kind of, for lack of a better term, you're kind of like puttering along, right?
Yeah.
And you're almost running a little bit on fumes and steams and getting through it, right? But get through it and learning and growing and understanding what you want to do, understanding more importantly what you don't want to do. And those first couple of years for everybody really are that stage where you're trying to figure out what works and, more importantly, what doesn't work, and stop doing the things that don't work. And just like you said, hey, this business thing, it works, but it's causing me more headache than profit. And so it's better to just double down on what works, which is personal injury, and just, let's just let this go and find these clients another home, or wrap these cases up and then just stop taking them one way or the other. So at 2000, you start your practice. Around 2002 or so, you start with Jim for about 18 months or 2 years, somewhere in that range, year and a half, 2 years. And then you go back and you back on your own. And at this point, you're still not kind of rolling in it, right? You're not like killing it. You're just kind of still in that startup phase. This is now year 3 of your practice, and you're still finding your zone, your strike zone. How many years from when you started your practice in 2000 do you feel like it took for you to really find that zone? And it doesn't matter if you were like killing it financially, but just like, okay, now I know where I'm at, and I'm just going to go all in on this.
I think it's probably around that 2003, 2004 time period. 2003, finished in 2003, I was, solo, still back to, keeping overhead down. I think I ran the back office from Sean Simpson for the second half of 2003 for like no money kind of thing. But again, could work the cases up, got money coming in, made more than I was making with Jim, just because it was on my own. And then 2004 had a partnership with Karen Wick for about 3 years, and we started getting into a rhythm of things, and that was all good. We went our separate ways in 2007, and Karen's had success, I've had success, but I'd say probably about 2003, 2004, it's like, this is going to be how I want to do things from here on out. We're solid. We're going to make this thing work. We're just
going to get the machine going.
Yeah, but also my mindset about what success was is completely different than it is now. And I kind of look back and go, all right, if I could have talked to myself a little bit, I would, advise me something different at that point in time. But at the time, definitely was happy.
Yeah, that's perfect. And so you're all in on personal injury. You basically were all in on personal injury starting, it's fair to say, like 2004.
Yeah, 2004. I mean, I'd get some referrals in for some business lit here and there, but it was like, I wasn't marketing for it. I wasn't putting myself out there for it.
Yeah. And I want to get into marketing because for those that don't know, down here in the San Diego market, Ross is advertising on TV. He's got his moniker, Get Ross, 877 Get Ross, right?
855 Get Ross.
855 Get Ross. I don't have cable, so I don't see it. I'm sorry, 855 Get Ross. And a mainstay out here in internet, TV advertising. So those days of 2003, 2004 are very different than today, obviously.
Yeah.
And I want to get into kind of that scale process, that, the second part of our discussion here. But before we do, one question I always like to ask, because I want to give the young people perspective, is, you went all in, you started your firm in 2000, and you went kind of all in on personal injury in 2003, 2004. When did you hit that first, one of the milestones I think every firm has, a person that starts their PI firm is, I want to settle $1 million case. That's like a milestone, right? That you're not going to retire on it, but that's just a milestone that I want to settle a 7-figure case. How long was it before you settled your first 7-figure case?
It might seem a long time for some people. It's, you asked me this question, it seemed a long time for me. It took 10 years.
10 years, yeah.
I thought I had one lined up in 2006 or so, and it just went sideways.
And that happens. Sometimes the client says something in the depot, and the case is gone, or some witness comes out of nowhere, or the doctor ends up changing his testimony for the records. I had a case one time where the doctor wrote in Kaiser Permanente records that he recommended surgery, like a fusion surgery. And when defense took the deposition of the doctor says, oh, that's a typo. I meant to say I do not recommend surgery. Well, it's like, what? So, these things happen in cases. And so, the reason I think that information is so important is people sometimes have a misconception that I'm going to start my firm, I'm going to do personal injury. They see everybody posting these big verdicts and big settlements, and they say, oh, I'm just going to settle these $1 million cases. They're everywhere. And they're tough to get. They're really sad because that means somebody is seriously injured. You need a lot of things to go right in the policy and litigation or pre-lit, whatever it may be. And it's hard to do it, and it takes time. And that's okay. It's okay that it takes time. It doesn't mean that you're not a successful practice. It doesn't mean that you're not going to make it. Everybody's on a different schedule, and it's okay to not worry about that happening right away.
I'd be very worried by somebody who is measuring their success by, how fast they get $1 million settlement or verdict.
True.
And the reason why I say that, along with what you just said, is, can you imagine a world where $1 million cases were, easy to pick up?
Right.
If there was that kind of volume, it would be a scary, horrible world, where people are dying and being dismembered on a daily basis. And thankfully, we don't live in that world. And it's getting safer and safer by the day with, the way we design cars, with automation systems, things like that. It's getting safer. There's a good market out there for cases that are going to be policy limits at 100, 250, 500,000, and you can make, just as much money. You'll have to work on more cases, but you can make just as much money as if you're getting $1 million verdict.
Right.
Yeah.
Right. No, that's exactly right.
Just be patient, be kind to yourself about things. And it's like the firms that are getting consistently $1 million cases, number one, they got the track record. So that's good. And they should be very proud of that. But number two, they are networking and they are cutting deals like crazy that you don't ever see on the back end in order to get those deals in. And it's cutthroat and competitive amongst those firms to get those cases.
Yeah, absolutely. Absolutely. So let's get into a little bit about scale. So you've kind of been a solo for several years. Maybe you're hiring some staff from 5, 6, but now you're at 34. So at what point was that inflection point in your practice, or was there an inflection point that you decided, okay, it's time for me to start advertising on TV. It's time for me to start, pushing the numbers a little bit. hiring more staff and handling more volume. How did that happen? And why did you decide to go down that path? Because there's different business models.
Right. So I can tell you how this happened retrospectively, looking back. At the moment, there's not really as much of a conscious decision about how to do things. It's kind of like, hey, I want to kind of go in this direction, and things kind of generate out of necessity. But I think part of the problem that most people have when they start off and they're starting their own firm, like I was in 2000 to even 2007, you think you're starting a practice, you think you're starting a business. But if you are the one who's working in the business and generating the revenue, and if you, God forbid, got in a car accident, were paralyzed or whatever it is, that revenue's gone. You don't have, if that's the case, you don't have a business, you have a job. You create a job for yourself, and that's fine. That's a great thing. There's a lot of solo attorneys that, their solo practice is I have a job and I hire an assistant, I maybe have an associate, and that's how my career is. And that's fine. That's great. Some people never want to progress past that point. It's simple. They understand it. That's great. At a certain point, though, through necessity, we started getting more cases. We started going, one of the disagreements I had with my ex-partner was I wanted to go on the internet. I wanted to have a website. I wanted to do SEO. I wanted to generate that way. And she was very happy getting cases solely through referrals. And when we split, that now allowed me to do that. So I started getting cases in the internet and generating that way, just solely through SEO, and started getting a volume of cases. I couldn't process them fast enough. So now I'm hiring associates, I'm hiring assistants, I'm growing the firm, and it's growing organically. There's nothing very intentional. It's just, you just kind of tell, we got to this point, we got to hire somebody else and go. It wasn't really until about, I want to say maybe 2012, 2015, when, I've always been working with coaches and trying to see, okay, well, look, let's talk to some people who know more than me, that have been exposed to more than me, and get their input on what I can do to improve, and get their input on what I can do to grow the business. And it wasn't until I started working with a couple of coaches who, or a couple of groups that I'm still working with, that I started seeing some, real possibilities about where we kind of go. And at that point in time,
and what was that? When was that in the timeline?
I think 2012. In 2008, 2009, I started working with Ben Glass out in Virginia, and was working with him for a couple of years, and then switched over to Vista Consulting, and maybe 2012, 2013. And I got introduced to their mastermind group in 2015. And I've been with their mastermind group since then. And that's when I got introduced to guys who, are on TV, who are doing all this mass advertising. Coming from San Diego's market is completely different than when I started. In fact, I'm not sure when you got started in the market here, but
it's 2012 for me.
Okay.
Or 13, actually.
Okay. Okay. Yeah. So you might have caught some of this then, but when I came into the plaintiff market here in San Diego, they were very much a reflection, I think, about San Diego. San Diego is the biggest small town in the world. They wanted to, like, we're homegrown. We're not Los Angeles. Whatever LA is, we ain't. And we just know each other. We treat each other right. And if you want to be a success in this town, you're going to do it the right way, which is you're going to take referrals from us, and build up your practice that way. And you're going to do it through trial work. And if you got a really big case, well, then you're going to refer it back to the big boys. And that's how we generate cases. And they always look very sideways at those who try to skip the process by going into advertising. Doesn't matter if it was Sam Spital back in the 80s and 90s. Jeff Phillips came in here for a while with Pacific Law Center and was advertising. People were looking sideways at him. But it was always just like, look, just do this organically, do this the right way, and be successful. Completely different approach, completely different way of doing things. So my mindset was always kind of like, okay, I can go only this far. Advertising, you have a website, SEO, maybe some PPC. That's about as far as I want to go. I don't really want to get into TV or radio, and nor did I have to, because nobody else is doing it in San Diego. Everybody else was playing by the rules then too.
Yeah.
So then I started talking to these firms, and I'm not sure what level they were at then, but I know what level they're at now, and they're 200 plus people, largest law firms in Arizona, largest law firms in Louisiana, and places like that.
These are the people that are part of your mastermind group.
Right, exactly. And it's like, wow, okay, so now I'm not sure I want to go complete that direction, but this has now opened my eyes to, okay, well, what do I want to do?
What's possible?
Yeah, what's possible.
Yeah.
About 2016, 2017, one of the great things in my office happened, and it wasn't by my choice. It was by my now managing partner, Stacey O'Neill's choice, as well as some of the other people who were in the office at that time. They basically said, we're going to fire you. And we need you to...
They said that to you?
Yeah, we're going to fire you. And I said, okay.
Yeah.
And I said, okay, well, what do you mean by that? I said, we need you to not be working on cases or only work on a few.
Yeah.
We need you out doing all the other stuff. We need you to do marketing. We need you to get your name out and stuff. We need you to do all this other things there. And that's kind of when things started kind of rolling there. I'm, not dedicating my time to working on cases or working on cases I shouldn't be working on. Again, you get back to learn what you shouldn't be doing, learn what you should be doing. That was another good inflection point, was to cull down to maybe like a handful of cases at most. And then otherwise just you're looking for opportunities, looking for things to grow.
And there's a couple of things I want to touch on and just highlight. One being, you went from sending all your own faxes, right, and answering your own calls and doing everything yourself, to realizing at a certain point, for the goal that I want to get to, and as you mentioned, everybody's got different goals, so there's no judgment on whatever anybody's goals are. Everybody's different. But for the goals that you personally wanted to get to, you realized through these coaches and maybe through your own self kind of analysis that it wasn't going to be because of your work. It was going to be because of the structure you're going to put in place and the space you were going to give your team members for them to go do what they do. And then you can work on things that actually move the business forward versus just moving a single case forward for one client.
Right. Well,
right.
And I think that's a good thing. Is, let's start with some foundational things. Why are you in the practice of law? Why are you doing all this? Like, what do you consider to be success? And, what's going to make you happy? What, and what's going to, at the end of the day, say, yeah, I'm doing a good job. I'm doing well professionally. And to me, and I guess also to my team, because they fired me, to me, it was building a business and watching other people have success and having success collectively. We've got our core values at our firm, and our core values really are about being good team members and being supportive of each other and treating wins as team wins, even though it might be your case, but this is a team win. We all work on cases together. If you're not available, somebody else can jump in on a phone call and you talk to the doctor or whatever it is. So this is a team win here, and to share success collectively. And I take a lot of satisfaction and a lot of joy in watching people grow and develop over the years to get to better and better success. And I am fine with I'm fine with
and just watching your team. You're talking about watching your team members from when they start at your firm to where they're at 3, 4, 5 years down the line, and how they've grown in their career. That's kind of what you're talking about, right?
Absolutely. And I don't need to have that personal, I'm a badass lawyer, here's what I did in trial, to feel good about it. I can say, look, I'm going to put the pieces where they need to be, and I'm going to put the assets where they need to be, and then I'll help coach you up, or I'll help, when you need some advice, or you need to, I'll put you in contact with whoever, you need to. But I'm taking much more of a satisfaction being a coach and being a manager than being in the trenches.
Yeah. And everybody's got their different thing that they identify with, right? Some people, like, as you mentioned, they want to be the trial guy or gal. That's what they want to be known as. And that's how they reach self-satisfaction, is that, hey, when I've got recognition in the community that I'm a badass trial lawyer, that's when I know that I've gotten successful. And some people kind of look at it differently, like you do. Like you say, hey, look, I've got this business where I've got team members coming in. They can be successful. Our clients are taken care of, and everything is kind of working together. That's how I look at success. And everybody's a little bit different. And I think that's an important factor for people to think about is, what is it that you would feel like is success for you?
Right.
And everybody's different, and there's no wrong answer. Another thing I wanted to highlight on what you talked about earlier about the San Diego market and how there was just this way. And I think it's true in a lot of markets, right? I think LA is probably an exception, but in most places, they are big, small towns. And there's a certain expectation that the established group have of newer incoming lawyers and newer incoming businesses. There's a certain expectation and a certain path that they expect you to follow. And you are not obligated to follow that path. Nobody is obligated to follow anybody else's path. That's the whole beauty of running your own thing and doing your own thing. Now, you have to keep in mind that You're going to deal with some backlash. You're going to deal with some side glances, whatever. But you have to be okay with that and have that self-confidence that I know what I'm doing is right. And if I'm going to do it my way, this is the way I want to do it. I don't want to do it just because somebody tells me I'm supposed to do it that way.
Right.
So, having that confidence early on and then not letting your ego get in the way, right? Everybody's got an ego. That's why we all start our practice, because we're like, I'm good enough to do this. You have to have some self-belief, but not letting your ego get in the way that I have to be the manager. I have to get the credit. I have to be the person that does this. I think those were some super important things that people need to think about. Is you don't have to follow anybody else's path, and don't let your ego get in the way of your own success.
Well, I think that, those are all good things to talk about. And we could get off into a huge tangent about entrepreneurs in general, trial lawyers specifically, and the battle of the ego, which then is a battle of, in my own personal experience, it's mental health. There's a lot of books out there about, there's one that says, the ego is the enemy, and it's true. You have to have an ego to have some success, but you also have to watch yourself and say, hey, look, I may not be the right person for this case, or I might not be the right person for this role or this job, and so in my office may be better than me, or I may need to hire somebody or outsource something because it's better that they do it than I do it. Taking a step out of oneself and looking at things honestly is good, not only for determining what you want, what brings you joy, and what's going to make you successful at the end of the day in your own mind, which is really the key. I mean, I don't really care if other people find me successful. That's great, but if I don't find myself to be successful, then that's who I got to go to bed with and sleep with tonight.
Exactly. That is 100% the key. It just doesn't matter what everybody else is doing or what they say or think about you, right? What matters is that you're happy with your life, your family's happy, your employees are happy, your clients are happy. If you've got that covered, you're good.
Yeah.
The rest is irrelevant. And, we touched on very early on in the 2000s, issues you dealt with, trying to generate business, trying to hire people, trying to grow, et cetera, et cetera. And then as you start to scale and you're at this point now where you're in masterminds, you've obviously got cash flow going, you're spending advertising, you're growing, you're making strategic decisions from a business perspective, from a marketing perspective, from a legal perspective. And that comes with its own set of problems, right? I think a lot of folks, when they start off, they think, oh man, if I can just get past this hill, or if I can just get this number, then my problems go away. But they don't go away. You just get a different set of problems. So what are some of the speed bumps or potholes you run into at a scaling perspective that were very different than what you dealt with at the beginning?
Well, scaling, particularly if you are in a contingency fee practice where you're waiting minimum typically of 6 months to maybe 2 years, maybe 30 months to get paid on a case, to get your case costs back, things like that. The biggest thing is you got to have access to cash. And, growth and scaling requires massive positive cash flow. And having a relationship with your bank, or having a relationship with a credit line, or something that you can tap into, and you can, have that for a rainy day, but then watching the dollars as a hawk, that's a big thing. I mean, gosh.
You got to have some appetite for risk there, right?
Yeah, and you do. And it's one of those things where, let's say I told myself 20 years ago what our monthly nut would be.
Yeah.
Now, it would scare the hell out of me. It would scare the hell out of me. It's crazy. Yeah. It's nuts. You're literally like the frog in the boiling pot, where you're taking on more and more risk. You're getting comfortable with more and more risk, but it's also that risk is managed. That risk is good. You understand that, okay, look, if I get used to this, if I put a little bit more, capital at risk, but not too much, this is good. It's going to come back. And if it doesn't come back on the schedule that I anticipate, it'll come back sooner rather than later.
Yeah. Did you spend a lot of time mapping out projections like that, right? Saying like, hey, look, this advertising contract I'm going to sign up for, whether it's SEO, whether it's TV, whatever it may be, is going to cost me this much over the lifetime of the contract. I expect, and ideally would get a return of, 2x, 3x, 4x, whatever I expect on my spend. And I anticipate that coming over 2 years. And if that doesn't happen and I just spend it and get zero, then I should still be okay based on the cases I have now and the inventory I have now. Is that kind of projection map you did? Or were there some shots in the dark where you're like, let's just go do this?
There's always shots in the dark, I wouldn't say, I mean, I'm a big nerd when it comes to, Excel spreadsheets, but a lot of the stuff that I do is literally on the back of a bar napkin and, just, kind of mapping things out. I can tell you when we started doing TV, it was, look, it's going to take at least 6 months to, the case we have today, it's going to take 6 months to get that money back. So how much cash do we have to have available for this contract to kind of sort of break even on it? And I mean, back of the napkin, we're like, it's going to take maybe 6 to 12 months of the contract to break even on that. And by the way, we won't even get traction for 6 months. So maybe it's even beyond 12 months at that point. But
you run ad, it's not like you run one ad and people start calling. It takes months for them to recognize the ad, recognize the branding. I mean, I'm your friend and I got the number wrong, right? So like it happens, right?
You actually named your fantasy football team 855 Don't Get Ross. So that's...
I did do that. That I did do. So I should have known. Just that. But no, 855 Get Ross. Ross is the good guy. I only did that because you were the commissioner. So I did that for you.
Anyway, it's a thankless job. It's fine.
The total thankless job. Yeah. So you got to kind of do this. You got to have this thought process. You got to do things intentionally. You can't just say, oh, other people are advertising, I got to go do that, right? Everybody is making these strategic decisions based on some of this math, even if it is back of the napkin stuff and it's not some, crazy projection. It's at least a thought process that, hey, I should make my money back on X amount of times. And if I don't, I'll be okay. And on all of these lines of credit, banks generally don't like contingency fee firms because it's not like you're an hourly firm that you can show monthly invoicing of this is how it works, blah, blah, blah. They generally don't like contingency fee firms because it's risk, right? You don't know if you're going to get your money back. You don't know if the case is going to settle. Now, we generally have a good idea of the value of a case through experience and knowledge, but banks can't value that. So what every single one of these banks do, and correct me if I'm wrong, unless you're dealing with the few banks that are very experienced in the PI space, and even those, I think, they make you personally guarantee this stuff.
Oh, yeah. No, everything's personally guaranteed, which is
everything's personally guaranteed. Risk. Yeah, it's way more risk. And for those of you that don't know what that means is, if it doesn't work out and you file bankruptcy on your business, you owe that money personally. So you borrow $500,000 because you want to run a TV campaign or a digital ad campaign, and it doesn't work out, and you go belly up, they're coming for your house.
Right.
This is not a corporate bankruptcy that you could just walk away from the stuff. So you got to have some appetite for risk, but you got to take these calculated risks where you do the math and you think to yourself, like, how do we prevent this extinction level? We don't want this to be an extinction level event. We want to take shots. We want to take risks and know that if it doesn't work out, we're still going to be a business. Fair to say?
Oh, absolutely. I mean, you always got to take risk. You always got to push things. And the problem now that I've noticed, especially since, the marker for me and maybe the marker for a lot of people is, COVID, is the world has changed in a number of different ways. Number one, there's fewer auto accidents, at least in California. I've been tracking the stats in terms of annual auto accidents, which is the bread and butter of every personal injury firm. And from 2020 to 2021, auto accidents got cut by more than 50% in San Diego County. It went from like 19,000 to less than 10,000. And the amount of lawyers, the amount of money chasing those cases didn't stay flat. It went up. We've got more competition now. We got more money in the market now chasing those. Yeah. So it's become a very, very competitive and very risky endeavor. Whereas, before you could probably forecast, hey, I'm going to get an ROI back of maybe five to six times. Now, your cost per case on a campaign, maybe you're looking at maybe 3 times, 4 times. And how are you going to make money on that if your, model was based upon, 5 to 6, times.
Yeah. And
ROI.
right. And then you got to pay, great. Because what people don't, people hear 3 to 1 and they go, oh, that's great. But they don't consider, hey, you still got to risk costs on that case. You still got to pay your employees. You still got to pay your overhead. So that's just a revenue. That's not a profit 3 to 1. That's hey, I spent $10,000. I got 30,000 back. And then from that 30,000, I got to pay everybody else. And hopefully there's something left over for profit, because profit's where.
And that's the whole thing, is that, the downside of this business is having to carry all your overhead for however long that case is going to. The proportionate overhead that you're dedicating to that case, you're just shelling out money until that check comes back in.
Right. So speaking of extinction level events, let's get to the third part of this, is talking about Florida tort reform. right? I think a lot of
Yep.
people from the outside, I don't have a practice in Florida, but I was looking at it. It was, kind of big news in the PI world of tort reform passing in Florida. And when I looked at the bill, or from what I've read online, it looks pretty draconian. It changed a lot. Now, some things, they just kind of made Florida in line with the rest of the country, like taking the statute of limitations from 4 years to 2 years, right? That kind of stuff. But some of the other things, like going from pure comparative to modified comparative, that affects a good chunk of cases. The medical being capped at a certain multiple, that affects a real big chunk of cases and value on cases. So, tell me, from your knowledge as a practitioner in Florida, what were the things that actually did pass, right? Because, I read all stuff online, but who knows how true that is. But what are the things that actually passed and that feel like really did affect the personal injury space?
All right. Well, I'll go ahead and say and be humble here that I've only been licensed in Florida for 2 years now at this point. So I'm a relatively new Florida lawyer. It is tough timing, but I want to be in Florida long term, and I did not choose Florida just because it was the litigation hellhole the Republicans make it out to be.
Right.
I chose it because I really do like Florida. I really do like the people, and I want Florida to be a place that is a home to me and my family for a long period of time. So that all being said, I've had a number of discussions with Florida lawyers.
The IRS listening and heard that.
Yes, exactly. Yeah, as soon as my homestead changes in a couple of years to Florida, just pay attention to that. Also, the California Franchise Tax Board needs to listen to that too.
Yeah, exactly. Take a look.
So I've been talking to a lot of lawyers about this in Florida, but I actually had a mediation yesterday and talked to the mediator about kind of the approach. So the bill does a lot, and I hope I'm not going to leave a lot of things out. So you mentioned it knocks down the general negligence statute of limitations from 4 to 2 years. To me, that's no big deal. Honestly, you should be pursuing cases quickly. That shouldn't really affect anybody on that.
Right.
You've got a move from pure comparative to modified comparative. Does that impact cases? Yes, it does. You've got this medical damages evaluation. We can get into that more, because I think that's probably the heart of really how this is going to affect the personal injury practice in the state of Florida. You've got a severe restriction on one of the things that Florida was known for, which is one-way attorney's fees for bad faith cases. So Florida still has not only first-party bad faith, they also have third-party bad faith, and your ability to collect attorney's fees for those is now severely limited. The other thing that they did, and I'm still trying to understand it a little bit, so if I get this wrong, somebody correct me, but from what I understand, when it comes to intervening criminal torts, like criminal assault on a property, somebody comes on the property, assaults somebody, that victim used to be able to sue not only the criminal tortfeasor, but also the property owner, and collect against the property owner for the intervening criminal act without having a deduction for the percentage of fault, percentage of harm caused by the intervening criminal party. That's now been changed, where basically a jury can look at everybody's percentage of fault, including the criminal tortfeasor and the victim, if the victim had any issues. It also creates a rebuttable presumption of fact for multifamily residential buildings, such as apartment complexes, condos, things like that, that if they do certain things, like put in security lights, put in deadbolts, that they're rebuttably presumed not to be negligent if a criminal act happens. Now, obviously, it's rebuttable. You can go present evidence. Yeah. There you go. But but
that's the general negligence.
Right. The biggest issues I see so far, just from talking to lawyers about this, is number one, it's going to severely hamper lawyers who were suing insurance companies for PIP. So PIP bad faith. Florida is one of the few remaining states that still has personal injury protection built in the statute. It's one of the reasons why their insurance laws are so backwards. And I think we should probably take a couple of seconds and talk about what was the impetus for this tort reform, because there's honestly a problem. There's a problem in Florida. Right. Trump's about to bash DeSantis in the primaries about this problem, and he's teeing up at this point. And I think we should talk about that.
And my understanding, and correct me if I'm wrong, my understanding of kind of the issue was with this one-way attorney's fees, which was anytime you sued an insurance company, they had to pay your attorney's fees, even if the case just settled. So you'd settle the case, even if it was nuisance value or whatever, they'd still have to pay your attorney's fees. And what that did is that encouraged some bad actors to just file on anything because they knew that they could get, a $5,000 settlement and then $5,000 in attorney's fees. And it caused, from a business perspective of the insurance companies, lots of unnecessary lawsuits that were there simply for the attorneys to gather attorney's fees, which caused some insurance companies to want to leave the state. Is that kind of an accurate summary?
I think that's a simplistic summary of one component of this.
Okay.
But yes, the one way of attorney's fees was definitely a hammer. And quite frankly, it should be a hammer to get your fees if you're suing your own insurance company. But yes, it along with other things was causing a problem. Florida has probably, if not absolutely, the worst property insurance market in the entire country. There is, I think at this point in time, maybe 2 insurance companies that service the entire state. They've had a couple fail. The Department of Insurance for the state of Florida is going to be allowing a surcharge on certain property insurance premiums so that the companies that are still in the market are going to collect a fee. That fee is going to go into a fund. My understanding is that fund is going to help shore up some of these insurance companies that are dissolving because they can't survive anymore on this. So there's a legitimate problem that the state of Florida was ostensibly trying to address. But the problem with tort reform is it's always a one-way street in terms of the negotiations. It's like, hey, if we give all this stuff to the insurance companies, we're not going to require them to promise to do anything. We're just hoping that more will come into the market. We're just hoping they're going to keep the premiums down. But we're going to do all this other stuff where we're going to hamper injured people from collecting the full value of their cases. And we're going to do all these other things where it's going to make it difficult to hire attorneys, or you're going to pay out of pocket for an attorney, and therefore, depending on your claim, it's not economically viable. So we're going to do all those things, and hopefully, God willing, the insurance companies are going to come back into Florida, and we're going to have some reasonable rates. It was so bad that there's actually, on the record, 5 or 6 Republicans in the state legislature and a supermajority Republican legislature who openly said, I wonder and worry if we're giving too much away to the insurance companies. Trump's come out already and said this is nothing but a giveaway to the insurance companies. DeSantis is bending over backwards for the great term of the day for the globalists. And, and he's going to hammer him on that. Meanwhile, DeSantis and the Republicans also had an opportunity last year, and DeSantis vowed he would never sign a bill. They had an opportunity to, on the auto side of things, bring Florida into line with how other states do their auto insurance policies by, requiring bodily injury coverage, which Florida does not require bodily injury coverage at all.
Yeah, I think that's interesting, right? Like a lot of us in California look at our $15K minimum and say, oh, that's way too low. And it just got raised to $30K. Yeah. And it's like, that still doesn't cover anything. But then you got Florida that doesn't have a requirement at all.
No, Florida has no requirement for liability, which makes obviously uninsured motorists, almost you have to have it. It has a 10/20 policy for minimum for if you do get bodily injury. The logic behind it is, okay, well, hey, we got this $10,000 PIP that'll take care of your medical bills in most cases. So really, we don't need to do, what everybody else is doing. But the Florida Association of Justice, even the Republicans, they were all on it. And DeSantis last year said, as long as I'm governor, I'm not signing that bill. So that's another thing that to kind of look at here. I think once he leaves, either in 2024 or when he gets termed out in 2026, and hopefully before then, you're going to see a change in that insurance laws. But getting back to the tort reform and the medicals, the news coverage of the actual bill is much worse than when you look at the actual language of the bill. And I think that the lawyers now are starting to look at the language of the bill and read through it. And from the ones that I've talked to, they are saying it's business as usual in terms of how they're going to take an aggressive stance on things. They're going to not adjust how they do things. They're going to continue using letters of protection, lien doctors where it's appropriate, even though now you're required to provide the copy of the lien, copy of the letter of protection to the insurance company prior to settling. You have to disclose that relationship prior to settling. They're going to continue doing this, doing business as usual, because the way they read the statute and the way I read the statute is we've come in Florida to where we are in California, which is we all get to argue what the reasonable cost of medical care is. And
Yeah.
you're going to,
Yeah.
and you on the defense now have various arguments that are provided in this legislation as to what the reasonable value of medical care is. It's going to be what the insurance company paid for it. It's going to, if there's no health insurance, but client is on Medicaid or Medicaid's available, you get, I think it's 170% of what Medicaid would.
What Medicaid?
Yeah.
Yeah.
And that's your argument.
That's what I read.
Yeah. And that's your argument for what's reasonable. And then we as a plaintiff bar get to get on this, you get there and with our experts and go, have you ever tried to get such and such procedure done for that amount of money? Number one, it'll never happen. Right. Or number two, my client is going to sit around and wait for years for a slot to open up. You want to pay for his pain and suffering for years? What's the value of that?
Right. That's higher than the medical care. Yeah.
Right.
So I see. Out here in California, we had that California Supreme Court case, Howell versus Hamilton Yeats years ago, that just, hey, this is how the meds are going to be determined. Whatever the insurance company paid, that's what the meds are in California, right? Not, that doesn't affect lead doctors, but it's the reasonable amount that's been paid. Now, that's just the standard out here because that's the law. There's case law that says that. It sounds like in Florida, there's room for interpretation on the statute. It wasn't that this is the only thing being allowed to be argued. It was, hey, they can introduce this evidence in trial, and then Florida lawyers can argue against it. But it's not like a motion to eliminate where the insurance company lawyer is going to have to file a motion to eliminate, say, hey, this plaintiff's attorney is actually barred from talking about how much these bills cost. They're only allowed to talk about 1.6 Medicare or Medicaid. It's not like that.
So, and this comes down to nobody knows how this is going to play out. I think in the long term, things are going to shift back to a more, let's say, more reasonable, more level-headed type of approach. But I think in the meantime, what is going to happen is, you're going to have both sides having arguments about what's reasonable on this, and are they both going to then take their time, spend their time in front of a jury arguing that, or are they going to do what sometimes happens in California, maybe other states too, where the sides get together and go, I don't know, like you're here, you're there, let's split the difference kind of thing, stipulate on what the value is, and let's go.
What the net bills are.
Yeah, exactly. And
because nobody wants to spend their time in trial. You don't want to be in a trial arguing over medical billing.
Right.
Like that's just not a trial that's going to get the jury on your side. And so the more you can kind of come to that agreement, and I know a lot of trial lawyers do this in California, and it sounds like that makes a lot of sense in Florida, is that if you could just come to an agreement on what the medical bills are going to be, that's way better.
It makes some sense, although, like I said, so I lived through Howell when that came through, and going from, hey, I can just submit the bills, and now I got to do this whole dance, and even for years after Howell, I still submitted just the bills, and the insurance company come back with whatever it was, and it's like, I really don't care. You just tell me what the number is that's going to sell this case, and it has to make sense to me based upon what my numbers are, and we'll fight it. And we've had so many fights since then. And I think Florida is now going to be going through that same fight about, what's the evidence about what's reasonable, what's not reasonable, and how that all works out. I mean, the legislation itself also puts into what's the reasonable value of future medical care. And it says the reasonable value of future medical care is you can take into consideration, is the person currently insured, or or is it Medicaid rates or whatever. Well, we fought that in California, and I'm sure other states have as well. Where
we got Pebbly out in California.
I mean the logical question, question to any expert on the defense who brings this up on medical care is, what basis do you have to believe that when my client needs insurance, that they're going to have insurance, and they're going to have this insurance, and it's going to be this level of reimbursement? It's purely speculative.
And it's going to cover this procedure or whatever it may be.
It's purely speculative.
And I think one of the arguments for Pebbly out here in California was, one of the arguments that carried the day, which was a good case for plaintiff lawyers, was that my client should have the ability to choose their own doctor when it's time for them to get their care.
Yes.
And if you limit their recovery to this cost of insurance, or you limit their recovery to, this particular cost, you're limiting their ability to choose their medical care, which nobody should be limited in that sense, right? You should be able to get, especially when it wasn't your fault, on why you need this medical care.
Well, to me, that's the number one reason against any type of argument about taking the bargain basement blue light special of how much to pay for medical care, which is, what does Medicaid pay? If you ever talk to a doctor about what Medicaid pays, it is there's no way any medical facility could ever survive and keep its doors open simply upon that. The only reason why Medicaid is accepted is because they have to by law in order to get other benefits, and they limit the number of Medicaid patients who are going to come in to the bare minimum that are allowed in order to keep that benefit. That's why Medicaid patients take. I mean, it's almost like Canada, where it takes 6 months to get an MRI, or it takes 2 years to get knee surgery, or something like that. Who wants that?
And there's a whole nother discussion there about, economic viability for the doctors, right? Mm-hmm. I'm seeing more and more in California, a lot of those top tier doctors are stepping away from the insurance game and just going cash only. And that's obviously sad for the folks that can't afford cash only doctors, but for those doctors, they don't want to deal with adjusters deciding medical care, deciding what treatment is needed and what treatment isn't needed. They don't want to dealing with insurance reimbursement rates, et cetera, and et cetera. And they just rather, I'll just have less clients that pay me a little bit more money, and I don't have to go get approval from somebody who's right out of high school, has no medical training at all, and they're denying my client getting the MRI. So now you're kind of in this whole ocean, and that's a whole nother discussion that we don't have time for today, but that's a whole nother thing to think about when it comes to these kinds of reimbursement.
Yeah, I can tell you this along those same lines. Yeah, any doctor who's doing care that is at the top level, or it's care that only a handful of doctors in the entire country or the world can provide, why are they going to go and get paid by insurance when they can get paid cash and not to deal with the problem? We have one case in Florida that it's going to be our test case on this, where I've got a young gal who was involved in an accident and basically had all of her teeth knocked out of her top part of her mouth. And she's now having bone degeneration. The doctors who can do this work are few and far between. She's going to have to get on an airplane, and she's going to have to go to California, Washington State, or into Florida, and she's got to find somebody who's going to do this, and it's going to be cash, it's going to be expensive, and they do not take health insurance, they do not take Medicaid. So what is a Florida court going to do?
Right. Yeah. It's going to be interesting to see. So it sounds like kind of where we're at today, being April 2023. For Florida tort reform is a wait and see. Let's wait and see.
Yeah.
The plaintiff's bar is going to find these test cases that they want to push and litigate on. I'm sure the defense is going to do the same thing. We'll watch it go through the Florida courts and see how the Florida courts respond in the appellate level, respond to these cases against the litigation and against equity, and just what's kind of reasonable in that sense.
Yeah, exactly. I think you're probably looking at a good 2 or 3 years of, we'll see what happens. And then in between that time, you're going to have both sides going, we don't know. We can't take as firm a stance as we want to. And it's kind of a holding pattern.
Interesting. Okay. Thank you, Ross, for your time. I don't want to take up any more of your time. We went longer than we normally do, but I didn't want to stop that discussion because I thought it was very insightful, and I appreciate that. As we kind of wrap up here, one of the things I always ask every guest is, if you could go back in time to the early years of when you started your practice and you couldn't tell younger Ross, you're still young, so you couldn't tell younger Ross, how it was all going to shake out, but you could give younger Ross some piece of counsel, some piece of advice. What would you say to younger Ross?
I think 2 things I'd say. Number one, only you can define what success is, and you have to be happy with what that definition is, and that'd be one piece of advice. Second piece of advice is, you say I'm young, I'm 48, gonna be 49 this year.
That's young.
Well, it's relatively young, but what I would say to my younger self is, you don't have as much time as you think. It goes fast. Recently went through, and it was every quarter we put together PowerPoints. We do a quarterly kickoff meeting for our team. I was putting together some PowerPoints here this last time or the year before, and I was pulling photos from 10 years ago, and taking a look at things and going, gosh, I was not even 40 then. And thinking about what my mindset was then, I was like, gosh, if I could have, done things differently back then, if I could have had a little bit more sense of urgency, a little bit more kind of a little less patience in some regards. I mean, patience is important, and you had to be patient. You had to be kind with yourself and with your team, but you also have to be impatient when it counts.
You got to be willing to put the foot on the gas.
Yes, exactly. But it's a give and take on the whole thing. But I would just tell myself, it's like, look, you don't have as much time as you think, and make sure that you are living and working towards your definition of success.
I love that. That's a great place to end. Thank you, Ross. And thank you for listening or watching. We'll see you on the next episode of Bootstrapped Solo. And remember, just because guys like Ross make it look effortless and easy, it doesn't mean that it is. So our one ask for you that are listening is if you enjoyed the podcast and you enjoyed Ross sharing his insights, please share it where you share stuff, LinkedIn, Instagram, TikTok, just text it to your friends, whatever. Let's grow the podcast. Let's get this good advice out to more and more people and help people achieve their level of success of whatever they want, of whatever that level may be. So thank you again. We appreciate you doing that. And thank you and see you next time on Bootstrapped Solo.